Okay, so this little presentation is about legal factors affecting business. They're mentioned here, so I'm going to go through them one by one. So where does law come from? Well, obviously the UK Parliament, and also at the moment we're still affected by EU law. Consumer protection law is, as it says, it's about protecting consumers from being exploited, typically by large businesses. Let's look at some examples of how consumer law might affect you. Let's say that in a few years' time, you buy a used car. You drive that car away from the garage and a couple of miles later, it breaks down. You can get all your money back. Why? Because that car is not fit for purpose. The purpose that you bought it for was to drive it around somewhere and have fun. It was not to have it sitting in a lay-by. Similarly, if you buy a broadband package, you get it home, it works, but it doesn't go at anything like the speed that is quoted by the seller. Again, you can get money back because it is not as they described it. Examples of where the EU has affected law. Well, a few years ago, if you took your mobile phone to Europe, there's a fair chance that you would be hit by what's called roaming charges, and sometimes these charges were huge. People were literally accidentally running up bills of £1,000 on a 2-week holiday simply because they hadn't changed their setting on that mobile phone. Well, the EU stopped that. Similarly, if you find that your plane or your train is cancelled or delayed, you will be entitled to compensation as a result of consumer protection law. Now, obviously, we can see how that's going to affect the business. Remember, this is A-level business, but as a consumer, you would clearly benefit from that. You're also protected in your role as a worker. So an employer cannot discriminate against you on a whole range of grounds: gender, age, disability, marriage, race, religion, sex, sexual orientation. Similarly, there are limitations on how long you can be asked to work, 48 hours a week. You can choose to do more than that, but they cannot force you to do more than that. A couple that aren't on this particular sheet say if an employer sacks you unfairly, then you can take them to court for unfair dismissal. If you resign, but the cause of that resignation is the actions of your employer, they've bullied you, they've harassed you or whatever, then you could potentially get a claim for constructive dismissal. They have constructed your dismissal. The biggie is mentioned down the bottom, the one that comes up most often on questions. It's the Minimum Wage Act, the National Minimum Wage. And again, this is the minimum that an employer can pay an employee per hour. Now, when we look at some counterbalance, pretty much your best one is going to be about trade union legislation, because over the years, things have been tougher for workers and easier for firms. There are a couple of exceptions to that. So, for example, if you want to take strike action, well, first of all, you must have a ballot of your members, and that ballot has got to be secret. You can't have a show of hands. You've got to give the employer 7 days notice. You cannot, while you're taking strike action, ask your mates in other industries to come round and picket the firm. That's called secondary picketing and is illegal. There's a limit on how many people you can have on the gates trying to persuade others not to work. On top of that, you cannot run what's called a closed shop, where in order to get work, you have to be a member of the union. It's slightly weird when you're travelling on Eurostar, because for many years, the British side of it actually didn't recognise the union at all. The French side of it, you had to be a member of the union in order to drive the train. So completely different situation in France. They actually had a closed shop. Situation has changed slightly. If half of your employees belong to a union, then that union must be recognised for negotiation purposes by the employer. Moving on to health and safety, the focus is on employee health and safety. So if you're at a college, you're there as a student, you're there effectively as a customer. But your teachers and lecturers, they will be covered by this legislation. The biggie is the Health and Safety at Work Act, where they've broadly got to protect you in terms of basic things like health and safety, obviously. It also covers things like whether you can get free eye tests. So if you use display screens a lot, which is what I do, then you are entitled to a free eye test. The next in the fascinating list of laws that that affect firms: environmental protection, very big. It's a bigger green agenda. You have to conform to certain environmental controls. You can't just pump a load of smoke up into the air, or you can't just pollute rivers and kill fish as you want to. So you have a duty to do that. Again, how can you respond to that? Well, possibly you can find new ways of doing things. You can find new products that actually conform and help here. So there are a range of things you can do. It isn't just a case of, well, we've got to pay up. So how does this legislation affect firms? In 2 words, it ain't good. Their costs are going to rise. For a start, they need to understand the legislation. Now, as an example of just how complex this is, let's take the national minimum wage. Minimum of £8.72 per hour. Simple, yeah? No. This could be an example that you could face in a few years' time. You've got a kid. That kid goes to school. You and your partner go to work, so you need that kid looked after by a childminder before and after school. You find one. You agree to pay them £6 an hour. You are now their employer. They are now your employee. Okay, £6 is below the national minimum wage. But luckily for you, there's 2 other parents who also use that same childminder. 3 6s are 18. The childminder is receiving £18 an hour, well above the national minimum wage. So it's all right for you to pay £6 an hour. Yeah. But what would happen if the other 2 parents no longer need that childminder? Their kids can go home by themselves. They're at that age now. That means that you are now the sole employer of that childminder. So would you have to increase the amount you pay them to £8.72 an hour? Answer, I've got no idea. But somewhere that has to be taken account of in the legislation. The legislation on something as simple as the national minimum wage runs into hundreds and thousands of pages. And if you're an employer, you've got to go through all of those pages to make sure how it affects you. You know, you could be something like a hotel chain. You employ thousands of cleaning staff, all of whom have got to be on that. Now, you've got to know exactly how you have to deal with those massive group of workers. And to do that, you're going to have to employ lawyers to go through that legislation to make sure that you are conforming to it. Lawyers are not cheap. You've also got to implement the legislation. Say on pollution, you might have to introduce noise limiters. You might have to introduce filters to make sure that smoke can't go into the atmosphere. There's a whole range of things that you might have to do there. Obvious one is the national minimum wage itself. For example, in 2020, it rose by 50p an hour. Well, anyone can afford an increase in pay of 50 quid an hour. Well, that's 20 quid a week. Let's imagine that you employ 500 workers. That's 10,000 a week, £10,000 a week extra. That's £500,000 a year. So it could easily be very expensive. That 50p per hour would increase by a very large scale. Thirdly, you're going to pay higher costs if you break the law. Now, it could be deliberate or it could be accidental, but you will face higher costs that way, as well as other things as well. You could also be affected on the revenue side of things. You break the law. Say, for example, that someone in your a manager in your organisation fails to put a safeguard on a particular bit of equipment, and sadly an employee dies or is badly injured. Well, the press are going to get involved. You might have an investigation by a TV crew. You're going to be taken to court. All of that is going to hit the press. So in addition to the increase in costs, you're also going to find a decrease in revenue. Your reputation will go down. But of course, don't forget the very small amount of counterbalance, the fact that employer legislation in terms of unions is likely to be in your favour. The final area of law that we need to look at is competition law. As the name implies, the aim of competition law is to ensure fair competition between firms. So you want to fight, but that fight has got to be fair. What would happen if you didn't have that? Well, large firms typically could exploit consumers, or they could exploit their suppliers. What do we mean by large? Well, the legal definition is where you have more than 25% of the market. That is where you are a legal monopoly. So Tesco, for example, are a legal monopoly in the supermarket industry. So let's imagine that you're one of the smaller firms. You would like to merge with another firm, and that merged firm is going to take you beyond that 25% point. What could happen to you there? Well, you might just be allowed to do it, or the opposite might happen. You might be told you can't do it. An example of that would be where Sainsbury's and Asda's wanted to merge. Both firms wanted it, and they weren't allowed to do it. That's why they are still there as separate firms today. Now, had that merger been allowed to go through, there's a reasonable chance that there would have been restrictions faced upon it. So they might, for example, have been forced to sell off some of their shops to their rivals like Morrison's or Tesco or the Co-op. So you might be stopped from doing what you want to do. You might be restricted on what sort of price you can set. So the water firms that serve your houses will be pretty much the same as everyone in your classroom. They are a local monopoly. Well, they will be restricted on how much they can charge. Similarly, rail firms are restricted on the maximum fare that they can charge. A couple of situations down the bottom. Sometimes firms agree to carve the market up. They agree to collectively collude and set a higher price. So in other words, they are not competing. That is a really big no-no, and firms can be fined hundreds of millions of pounds if they're found out. British Airways has been found colluding and fined nearly 300 million euros. The banks were colluding big time on interest rates just before the financial crisis. They're still being fined to this day, and the total amount of fines is in, it's probably around about the 10 million euro mark now. So really, really, really big fines. So if you charge too high a price by collusion, you can be fined. But also there's an interesting situation at the other end of things. If you engage in predatory pricing, now that is where you are selling at too low a price. You're actually selling below your cost. You're aiming to run a short-term loss so you can knock a rival out the market and then jack your price up again afterwards. So you're engaging in a fight, but that fight is unfair. It's like a boxer punching below the belt, which is actually quite painful. Is that allowed? No, and that is fined in exactly the same way as if you collude. It is an absolute no-no. Well, I hope you've enjoyed this absolutely fascinating tour around legal policy and how it affects British firms, every firm actually.